everyone, Dwayne Boswell O'Shell here with our weekly Facebook Live Ask an Attorney. And we're going to continue talking about the Deceptive Trade Practices Act here in Texas and how you as a business owner can protect yourself from possibly having to pay somebody 3 times their damages for violating that. But first, I just want to say, cooler weather is here, so I hope everybody gets to enjoy some time outdoors. I know it comes with kind of for me, I have a lot of allergies that arise in the fall, and so going outside, I love being outside, especially in weather like this. And then I pay for it later with some allergies, but I think it's well worth it. But we've got Halloween tomorrow, and I'm looking forward and hoping to see some trick or treaters, and that COVID doesn't scare people too much, so that we don't get to celebrate that fun time that we have every year with our kiddos. I miss it. Mine are grown now, but we all still enjoy the trick-or-treaters that come to the house. So be safe tomorrow and have fun. And now we'll start talking about the thing that's not quite as fun, but hopefully will provide you the education you need as a business owner to protect yourself and not do something that could wind you up in hot water for violating the deceptive trade practices. So you'll kind of see me look over to the side is because I have a second monitor that's much bigger than the one where my camera is. And after all the time that I've spent on the computer over the last few months, my eyes need the bigger screen. So we're going to start with Section 19 of the Deceptive Trade Practices Act, which once again is found in the Business and Commerce Code. And it's Section 17.46 is where we have what we call the laundry list of things that you can violate. And there are about 34 of those things that you can violate, and we are on number 19. And number 19 and number 21 actually kind of go together. So 19 is you use or employ a chain referral sales plan in connection with the sale or offer to sell of goods, merchandise, or anything of value, which uses the sales technique, plan, arrangement, or agreement in which a buyer or prospective buyer is offered the opportunity to purchase merchandise or goods, and in connection with that purchase, receives the seller's promise or representation that the buyer shall have the right to receive compensation and consideration in any form for furnishing to the seller the names of other prospective buyers if the receipt of the compensation or consideration is contingent upon the occurrence of an event subsequent to the time the buyer purchases them. And then 21 is promoting a pyramid promotional scheme. So we see a lot of these organizations that set up where you have, hey, you can buy this, and then you become a consultant and you sell it to others, and then some of those that you sell to become a consultant. So those don't necessarily violate in of itself these two provisions of the DTPA, but it is something to be very, very cautious of, and to make sure that you become very, very familiar with what is allowed and what's not allowed in those types of situations. I know there is a class action lawsuit that is being decided against Ambit Energy right now, and Texas hasn't weighed in on that at all right now. Some other states have, but that's a fight that's out there right now. And then there's some other big companies that do it as well. So just make sure that if that is a way that your business operates, that you know the parameters that you can operate within. And I'm sure that Ambit Energy has really looked into that because they're a pretty big company and well known, and they're based here in Texas. So I'm sure that they've looked into that, and they have legal counsel that's advising them on that. But it is something to be aware of. Each state has a different laws based on the DTPA, and there's a federal statute for it, and then each state will have their own as well. So if you operate in multiple states, you're going to want to make sure that you know that law in every single state that you operate in if you have a setup that's similar to this. So I don't want to in any way say that anybody who's doing anything wrong in the way that they've set up. You just want to make sure that you know these two provisions specifically and do some research on how those would be violated before you start practicing with those. Another one is failing to disclose information concerning goods or services which you knew at the time of the transaction. If you are purposely withholding that information to induce them to buy it. So if you know that, I always go back to cars because that's usually the one that we see the most often on these. So if you know you have a car that's got a transmission problem and you tell them that, no, it's perfectly good and working when you know it's not, then you can get in trouble under the DTPA. Now, it doesn't necessarily mean that a private sale will subject you to this. You have to be a business owner. There has to be a certain number of transactions that you do before the DTPA actually applies to you. So we also have using the term corporation, incorporated, or an abbreviation of either to those terms, some way implying that you have a corporation that has been set up in the state when in actuality you haven't. If you're using that name when you're not incorporated under laws of the state or another jurisdiction. So you can be incorporated in one of the other states or even another country as long as you have a consideration or a actual formation under some jurisdiction. So if you have a small company, you want to make yourself look bigger, so you just put Inc. on the end of it. You can't use that term unless you are actually incorporated as a corporation with a state or another country. So then we have selling or offering to sell I lost my place. Selling or offering to sell or illegally promoting an annuity contract with the intent that the annuity contract will be the subject of a salary reduction agreement. And there's all kinds of other statutes that tie into that one. So I would just really encourage, if you have any kind of an annuity and you're going to reduce pay or anything, that you follow all the rules that you need to set that up. I would contract with somebody or hire somebody that's an expert in that area. So, representing that work or services have been performed on or parts replaced in goods when the work or services were not performed or the parts replaced. That one's a pretty obvious one. If you say that you've made a repair to something, make sure that you've made that repair. So filing suit founded upon a written contractual obligation of someone that's signed by that person to pay money rising out of or based on a consumer transaction for goods, services, loans, extension of credit. So basically you've got a contract that you're going to exchange money for a service or a good, and something happens and the person that you owe the money to files a lawsuit in a county where either you do not reside or in a county where the contract wasn't signed. And they file a lawsuit, and they know that you don't live in that county or that the contract wasn't filed in that county or signed in that county, then that is actually a violation of the Deceptive Trade Practices Act, and you can file a lawsuit on that. Now, I would caution you, most contracts have a venue clause in them, or a forum clause, it may be called, where you are actually agreeing where the any disputes regarding that contract, the county in which it will be heard. So you want to make sure you look for those in any contracts. But if they sue in any county other than the one mentioned in the contract, or where you live, or where the contract was signed, then you can actually bring this suit against them and recover some money from them for them filing in the wrong county. I always thought that one was kind of interesting, but that goes the other way as well, that you as a business owner need to make sure that you're filing in the right county, because you can open yourself up to being sued under the DTPA Act if you file in an incorrect county. Now, it doesn't really apply if you aren't knowledgeable. So if you didn't know that the county that you sued in wasn't the proper county, then they're going to have a little trouble getting you with this. But if you know and you file in the wrong county, you can't get in trouble. Let's see, where are we? So, here's a big one that, especially right now with all the hurricanes that have been happening, is taking advantage of a disaster declared by the governor or the president of the United States by selling or leasing fuel, food, medicine, lodging, building materials, construction tools, or another necessity at an exorbitant or excessive price, or demanding an exorbitant or excessive price in connection with the sale or lease of fuel, food, medicine, lodging, building materials, construction tools, or other necessity. So this would be if somebody raised their prices suddenly for gasoline right before a hurricane was to hit, or right after a hurricane. They can get in a lot of trouble for that. So you as a business owner want to make sure that you are charging the same prices for merchandise, and whether there's a disaster or not, and then you'll be safe from possible liability under this provision. Let's see, so taking advantage of a disaster, we did that one. Let's see, where are we? Demanding, using a translation into a foreign language of a title or other word, including attorney, immigration consultant, immigration expert, lawyer, licensed, notary public, in any written or electronic material, including an advertisement, a business card, a letterhead, or online video, in reference to a person who is not an attorney, in order to imply that the person is authorized to practice law. That's a lot of words to saying, don't advertise that you can practice law if you're not a licensed attorney. You don't want to make sure that, especially if you are translating into another language, you want to make sure that you don't give the impression that you are a licensed attorney able to practice law in any advertisement that you do. That one's a pretty obvious thing. You should not tell somebody you can practice law when you cannot. Delivering or distributing a solicitation in connection with a good or service that represents that the solicitation is sent on behalf of a government entity when it is not, or if it resembles a government notice or form that represents or implies that a criminal penalty may be imposed if the recipient does not remit payment for the good or service. There's a lot of scams out there, guys. Don't be one of the people that do it. So you want to make sure that any advertisements you send do not look like an official notice from a government agency. And you definitely don't want to imply that somebody is going to be penalized, especially by money, for not purchasing the product or service that you are advertising. That can get you in some big trouble. It's not even just this statute. There's some other statutes that you could get in trouble with. So basically just make sure your advertisements are legitimate and that they are advertising your goods or service, and that there's no other connotations with that it's a government agent. I'm sure that we've all gotten the scam calls from, we have a problem with our social security number and they're going to come arrest us if we don't call and pay this money. Well, if we could ever find those people that are doing that, they would be subject to the DTPA. Problem is you're never going to find those. But just know that they will not come arrest you for any kind of a debt that you owe. Unless you've already been to court, and there's a whole lot of caveats to that statement, but typically we don't imprison people for debts. IRS is something completely different, and there's a whole bunch of different things with that. But generally speaking, you're not going to be put in jail for a debt. Delivering a solicitation in connection with a good or service that resembles a check or other negotiable instrument or invoice, unless the portion of the solicitation that resembles that check or other negotiable instrument or invoice includes the following notice that's clear and conspicuously printed in at least 18-point type of specimen not negotiable. or non-negotiable. So I know I've received a lot of solicitations in the mail for loans, and it looks like there's a check in there. Well, right underneath the, or somewhere on that check is usually specimen not negotiable, or some other phrase that indicates that this isn't really a check. But that's, you know, you got to be really careful if you're going to do something like that as a business owner, to make sure that you have it at 18-point type. It's big, it's conspicuous, they know that this is not actually a check that they can go and cash. For me, the better practice is just don't do that. Just send them an advertisement that doesn't look like a check. So in the production, sale, distribution, or promotion of a synthetic substance that produces and intended to produce an effect when consumed or ingested similar to or in excess of the effect of a controlled substance or controlled substance analog, as they're designed, as those terms are defined in the Health and Safety Code. Making a deceptive representation or designation about the synthetic substance, or causing confusion or misunderstanding to the effects the synthetic substance causes when consumed or ingested. And we have a lot of CBC store owners, so that may be one that you want to make sure that you understand what that means, so that you don't run afoul of violating the DTPA. So you wouldn't want to say that, you know, they're going to get the same effects from CBD as they do from smoking marijuana. And confusing that the CBD oil is actually marijuana. Anyway, that's pretty much what that is saying, is if it's synthetic and it's not the actual controlled substance, then you don't want to advertise that it's going to be the same as that subject. I don't know why anybody would actually want to advertise that they're selling something that's like a controlled substance, because that could open them up to some criminal liability. So it's probably just not a smart idea. Just advertise your product the way it is, and you'll be fine. Another one is a licensed public insurance adjuster, directly or indirectly soliciting employment for an attorney or licensed public insurance adjuster, entering contract with the insured for the primary purpose of referring the insured to an attorney without the intent to actually perform the services customarily provided by a licensed public insurance adjuster. Provided that this subdivision may not be construed to prohibit a licensed insurance adjuster from recommending a particular attorney to an insured. So this is going to happen a lot in personal injury cases where we have car accidents. They're basically saying that the adjuster for the insurance, they may not work, but sometimes the insurance company will hire a private one. But this is a licensed public insurance adjuster, basically getting you to an attorney, which will also refer cases back to them. So it's just something that normally happens, and most business owners don't need to worry about that. So unless you're a licensed public insurance adjuster or an attorney that does personal injury, that provision probably isn't going to be something that you're going to run afoul of. Owning, operating, maintaining, or advertising a massage establishment that is not appropriately licensed, or it's not in compliance with the applicable licensing or other requirements, or is not in compliance with an applicable local ordinance relating to the licensing and regulation of massage establishment. So, pretty obvious, if you run a massage parlor, make sure that you're licensed and that you're obeying all the regulations of that license. And last but not least, we have a warrantor of a vehicle protection with product warranty using in connection with the product, a name that includes casualty, surety, insurance, mutual, or any other word descriptive of an insurance business, including property or casualty insurance or a surety business. Basically, they're just saying make sure that people don't believe that you are a insurance provider instead of somebody that's providing a warranty. So, some of these are very specific to certain industries, and most business owners aren't going to have to worry about that. But that's a quick rundown over, last 3 or 4 weeks of the DTPA. It's much more complicated than we can actually talk about in these short videos. But I figure if I give you a little bit of information to protect you against some of the common things that can happen under the DTPA without you really intending to do them, at least you'll have some knowledge that you can go back and make sure that your practices aren't in violation. So anyway, once again, everyone, have a very happy Halloween, and I will see you next Friday. Oh, and if you have any questions, feel free to direct message me on Facebook. You can also email me at dwayna@boswelltexaslaw.com, or you can give me a call, and we have a free 15-minute consultation via the phone, and that number is 832-919-6595. I look forward to hearing from you all, and as always, if you have any questions that you want me to answer on one of these installments, send them to me, and I will make sure you get your answer. Anyway, have a great weekend, and we'll see you next week.